You are standing at the stove making breakfast for your kids when your phone buzzes with a message from a neighbor 2 streets over. The message says 3 words. They are here. You look out your front window and you see 2 unmarked black SUVs parked at the end of the block. Men in dark jackets are moving house to house. Your youngest is eating cereal at the kitchen table, completely unaware. Your oldest is in the shower. You have maybe 4 minutes before those vehicles reach your address. Your hands go numb, your chest tightens. And the question that hits you harder than anything else is not whether you will be taken. The question is, who will pick up your children from school today if you are gone? Because in this moment, you are not thinking about courts or lawyers or constitutional amendments. You are thinking about your kids eating cereal at that table and what happens to them in the next 4 minutes. And I am here to tell you that what you do in those 4 minutes is the difference between your family staying intact and your family being torn apart by a system that is moving faster and hitting harder than at any other point in modern American history. What is unfolding across the United States right now is not a routine enforcement cycle. Government officials and independent legal monitors have both confirmed that the current wave of ICE operations represents the most expansive and aggressive immigration enforcement campaign this country has seen in its modern history. Operations are running simultaneously in major metropolitan areas and in small towns that have never seen this level of federal presence. The targets are not limited to individuals with serious criminal convictions. The nets being cast right now are pulling in people with decades of community roots, people with American-born children, people who checked in with ICE voluntarily for years under supervision agreements, people who had pending applications, and people who simply had an old immigration case that was never resolved. The numbers being reported by DHS are not the full picture. For every person in a headline, there are dozens more whose stories never get told because their families are too afraid to speak. And the reason so many people are being caught in this wave, the reason families that should have had options are instead being processed for removal, comes down to one thing. They did not know what they were legally allowed to do when the moment arrived. And by the time they found out, the moment had already passed. Here is the trap. And I want you to understand this trap deeply because it is built specifically to work against you. When ICE conducts a residential operation, the entire encounter is designed to compress your decision-making time to almost nothing. The knock is loud and sudden. The presence of multiple officers in official gear creates immediate psychological overwhelm. And then comes the specific legal trap that almost no one sees until it is too late. The officer at your door may say something like, "We have a warrant for the person at this address." That sentence sounds like a command. It sounds like the legal process has already been completed and your only remaining role is to comply. But that sentence is not the same as having a judicial warrant. An ICE officer can say those words while holding an administrative warrant, which is an internal DHS document that does not carry the same legal authority as a warrant issued and signed by a federal judge. The trap is that both documents are called warrants. Both are presented with equal authority and confidence. And the overwhelming majority of people, when they hear the word warrant spoken by a federal officer with a badge, open the door. They open it because they believe they have no legal choice. They open it because, in their home country, not opening the door for an official with a warrant would have had catastrophic consequences. They open it because every instinct they have says that resisting a government official makes things worse. But here in the United States, under the Fourth Amendment, opening that door without verifying the type of warrant is a voluntary act. And that voluntary act has legal consequences that follow you all the way to immigration court. The second layer of the trap begins the moment you are face to face with the officers. ICE agents receive training in behavioral interview techniques. They may be calm and even friendly. They may tell you this is just routine. They may use your first name, which means they already have information about you. And hearing your name spoken by a federal officer in your own doorway is deeply disorienting. They may mention that a neighbor or coworker has already spoken to them, implying that there is no point in being uncooperative. They may say that anything you tell them will help them understand your situation better. None of this is legally binding on you, but it is psychologically designed to make you start talking. And once you start talking, once you confirm your name, your country of birth, the date you arrived, whether your visa is current, any of those things, you have provided testimony that becomes part of the record in any future removal proceeding. The trap does not close at the door. The trap closes in the conversation that happens after you open it. Now let me hand you the legal shield. Let me give you the framework that federal law provides so that you can walk through this moment protected. The Fourth Amendment to the United States Constitution guarantees every person on American soil, regardless of immigration status, the right to be free from unreasonable searches and seizures. Courts at every level, including the Supreme Court, have affirmed that this protection extends to non-citizens. Your home receives the highest level of Fourth Amendment protection that exists in American law. ICE officers cannot legally enter your home without either your voluntary consent or a valid judicial warrant. A judicial warrant is a document signed by a federal judge or magistrate. It will carry the name of a court, a case or docket number, a judge's signature, and a specific address. An administrative warrant, which is the form ICE typically carries during residential operations, is signed internally by a DHS official. It is not issued by a court. It does not grant officers the legal authority to cross the threshold of your home against your will. This is not an opinion or a political position. This is settled constitutional law that has been reaffirmed in federal courts across the country. The Fifth Amendment provides your second layer of protection. You have the right to remain silent. You cannot be compelled to be a witness against yourself. This right is not suspended during an immigration encounter. You do not have to answer questions about your immigration status, your country of origin, how you entered the United States, or how long you have been here. Under 8 U.S. Code Section 1357, ICE has the authority to ask those questions, but you have the constitutional authority to decline to answer them and to request that any questioning take place in the presence of an attorney. These two amendments together, the Fourth and the Fifth, are not theoretical protections for a future court date. They are tools you can activate right now, in real time, during the encounter itself, but only if you know them before the knock comes. It is also important to understand the current policy environment accurately. In 2025, DHS formally rescinded the Enforcement Priorities Memo that had been in place and that had directed ICE to focus resources primarily on individuals with serious criminal histories. The current directive, issued from DHS headquarters, removes those priority distinctions and designates the enforcement of immigration law broadly across all categories of civil immigration violations. This means the informal protection that many people relied on, the idea that if you had no criminal record, you would not be a target, no longer reflects current policy. Every person with an unresolved immigration matter is now operating in an environment where their risk of being encountered has materially increased. Let me now address the misinformation that is actively causing harm in immigrant communities. The first and most dangerous rumor is that ICE cannot enter your home without a warrant, full stop, so you are safe. This is only partially true, and the incomplete version of it is getting people hurt. Yes, ICE cannot enter without a judicial warrant or your consent, but the key word is consent. If you open your door, you may be found to have consented. If you step outside, officers can detain you in a public space without a warrant. The protection only works if you know how to assert it correctly. Knowing half of a legal rule without knowing how to apply it is almost as dangerous as not knowing it at all. The second piece of misinformation being shared widely is that you should immediately record ICE officers on your phone and show it to them to scare them off. Recording officers in a public space or through your window is generally your legal right. But using the act of recording as a confrontational tactic or showing the camera directly to officers in an aggressive manner does not end an encounter and can escalate it. Record if you can do so safely and calmly. Recording is evidence. It is not a shield in the moment. The third rumor is that if ICE has already issued a notice to appear, your situation is hopeless and there is nothing left to do. This is absolutely false. A notice to appear, or NTA, is the beginning of a legal process, not the end of one. It initiates removal proceedings in immigration court. It does not mean a final order has been issued. It does not mean you have no legal options. People with pending NTAs have successfully applied for cancellation of removal, asylum, adjustment of status based on qualifying family relationships, and other forms of relief. The moment you receive an NTA is the moment you need an immigration attorney, not later, immediately. Here is your action plan. Here is exactly what you do and exactly what you say. The first step happens right now, before anything else. You designate an emergency contact for your children. This person must be someone who is legally present in the United States, who your children know and trust, who has your permission documented in writing to make emergency decisions for your kids. Write that authorization letter today. Have it notarized if possible. Keep a copy in your home and give a copy to that person. Your children should know this person's phone number by memory. The second step is to prepare your response before the knock ever comes. If officers arrive at your door, you do not open it. You speak through the closed door. You say these exact words. I do not consent to entry into my home. Do you have a judicial warrant signed by a federal judge? Say that clearly, stay calm, and wait for the response. The third step is to examine any warrant they present before you make any decision. Ask them to slide it under the door. When you have it in your hand, look for a court name, a judge's signature, a docket or case number, and your specific address. If those elements are not present, you say, "This does not appear to be a judicial warrant signed by a judge. I do not consent to entry, and I am asserting my Fourth Amendment rights." Then you stop talking. The fourth step is to invoke your Fifth Amendment right immediately and completely. The script is simple. I am choosing to remain silent. I want to speak with an attorney before answering any questions. You say this once. You repeat it if they continue. You say nothing else. You do not explain why you are silent. You do not justify it. You do not say anything that confirms your name, your nationality, or your history. Silence is not guilt. Silence is a constitutional right. The fifth step is to contact legal help the moment it is safe to do so. Every immigrant household in America should have 2 phone numbers written on a physical card right now. The number of an immigration attorney or a nonprofit legal aid organization in your area, and the number for the ACLU's Immigrants' Rights Project. Do not rely on finding these numbers in a moment of crisis. Find them today. Write them down. Put them in your wallet, on your refrigerator, and in your children's backpacks. The sixth step applies specifically to anyone who has received a notice to appear or who has an existing immigration case. Pull your case records today. Log into the EOIR Immigration Court portal at justice.gov and confirm your next hearing date. Confirm the court location. Confirm that your address on file is current. A missed hearing results in an automatic removal order issued in your absence. That order closes doors that are very difficult to reopen. Show up. Bring documentation of your ties to this country, your children, your employment, your tax records, your community involvement. Every piece of evidence of your life here is relevant to your case. My name is James. I am a senior immigration analyst with 6 years of experience. And on Immigration News Today, I do not give you opinions. I give you the survival strategies that keep families together. What is happening right now is the largest enforcement wave this country has seen in a generation. But large does not mean unstoppable. Powerful does not mean unconstitutional. The families who are getting through this are the ones who prepared. They knew the difference between a judicial warrant and an administrative warrant. They had their emergency contact designated. They knew the script. Now you know it too. Immigration rules change overnight. Join my WhatsApp community for instant alerts before I post on YouTube. The link is in the description. When DHS issues a new directive, when a federal court rules on a critical case, when enforcement patterns shift in your city or your state, you will know about it in my WhatsApp community before it reaches anywhere else. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Staying informed is no longer optional, it is essential. I am James. Protect your status, protect your family. I will see you in the next update.